All right, our top story again at 4:30. The story we've been following today, Raul Valle found not guilty of murder and intentional manslaughter in that Shelton house party murder trial. He had been charged in the 2022 stabbing death of 17-year-old Jimmy McGrath. And joining us now to talk more about this verdict and deliberations is former Connecticut State Prosecutor Ryan McGuigan. This is an interesting thing. We talked about this a little bit earlier. Not guilty on many of these counts. There were a handful of counts where they could not reach a decision in the jury. And the question is, what happens next? And as you outlined at the top, it could be another trial, but probably not in your estimation, right? Tell me again about that.
So you have to look at what the jury found. And what they clearly found is that Mr. Valle was acting in self-defense, which to prove that, you have to put on the defense has to put on some evidence that he was acting in self-defense. And in this particular case, they put on the best type of evidence, which is the defendant.
Yeah.
And he got on the stand, and he obviously was very persuasive with the jury and convinced them that at the time that this was happening, he felt as if his life was in danger. And he wasn't acting to hurt anybody. He was acting to get away from the danger that was threatening his life. So in that circumstance, he could be retried for reckless actions based on reckless conduct. But it's very difficult to imagine how the state would bring that charge logically after this jury had found very quickly and almost unanimously from the get-go, it looks like it was 11-1, that he did indeed act in self-defense, and they were persuaded by that. So under those circumstances, it's very difficult to imagine a scenario of how the state would come up with a theory that he acted recklessly.
Let's talk about that. So a couple of hours after they started deliberating, they came to the judge and said, 11-1, we cannot reach a verdict. Apparently now we know, at least we think, it was 11 for not guilty and 1 for guilty, and they changed that person's mind. How unusual is that setup, where that quickly it would be 11-1 not guilty? Or I guess every case is unique, right?
True. However, we do all have to understand that the state brings all these charges, and they have the discretion whether to bring the charge or not to bring the charge. And when they do charge somebody and they arrest them, usually they have a very strong case. Especially if it's done by way of a warrant, because right from the beginning, the prosecutor is involved in the process of drafting the warrant, and they talk to the police, and the police will ask them, well, do you think we should bring the charges or not? So under circumstances like that, all of the benefits lie with the state and not with the defense. So in a scenario like that, it's very difficult or it's very odd for a jury to come back so quickly.
Yeah.
With a not guilty, which really is a resounding comment on how they feel about the state bringing the charges in the first place.
A little better than half a minute left here. Is the door now still open? The criminal part may be over. The door still open for a civil trial in this case? So talk us through that. How would that work?
Sure. You remember the O.J. Simpson trial?
Sure.
Yep. And he was acquitted of the criminal conduct. However, the family of Nicole Brown Simpson and Ronald Goldman then brought a civil suit against the estate against O.J. Simpson. Mm-hmm. And they won a jury verdict, but the burden of proof
is lower.
Lower. It's a preponderance of the evidence. So what does that mean? It's more likely than not. So it's 50.01% for he's accountable for this, or 49.9% that he's not. So that's all you have to find is just a little bit over, half persuaded. And then that's good enough for a civil trial. In a criminal trial, it's beyond a reasonable doubt.
And we have no indication yet that the family plans that, but that's just an avenue, as we've seen in the past, that could happen. Ryan McGuigan, former state prosecutor, we appreciate your insight again, my friend.
Thank you much.
All right, we'll see you later.